Welcome to the Military Justice Today podcast with your host, Robert Capovilla and Mickey Williams, covering the full range of military law topics from all branches of the armed forces. Today's episode is made possible in part by the law firm of Capovilla and Williams. And now, let's welcome the hosts of the show, Rob and Mickey.
Okay, we are back in the studio outside of Atlanta, Georgia, next to Truist Park. I'm Matt Starosiak. With me is my good friend and colleague, Robert Capovilla. We're going to do another episode of Military Justice today. And Robert, look what we have in the podcast studio with us today.
We've got the one and only Josh Conklin. The man, the myth, the legend is here.
Otherwise known as the Conk or
the Conk.
Mr. Joshua or Spencer Strider.
That's true. For those who have never visited our website, and we're not video recording this particular podcast episode, Josh has a striking resemblance to Spencer Strider. It's striking. I mean, that's the best way to describe it, right? It's uncanny.
Yeah, Josh is better looking, though, for sure.
I may also be a foot shorter, but I've been mistaken for him in public more than once, which is shocking.
Why don't you leverage that? Like, I would show up at the Braves game with a shirt that says not Spencer, you know?
No, I know it. If I just put a hat on, I could walk right in.
Did you ever see that guy who showed up at Aaron Rodgers, one of Aaron Rodgers' game? He was from
Yes.
England or you know, and he showed up and he looked just like Aaron Rodgers.
Yes, I saw it like on X or Twitter or whatever it's called these days. I think I saw it there.
And he got his 15 minutes of fame. I would do that, Josh, if I
He was
were
identical. Yeah, I could do it.
Yeah,
Again,
you could.
foot shorter.
Well, nobody knows that, though.
I'll just
Really?
get big shoes.
Yeah. Your thighs are bigger than his, though, too.
Absolutely.
I don't know about that one. Spencer Strider, those legs that he's got on him, those are like bodybuilder legs.
Tree trunks.
Yeah, I've read about him. He's like an absolute. He's like absolutely dedicated to his fitness and what he eats. He's very intense in his workouts and trainings. He's like eating the same thing every day for like 3 years. He's one of those kind of guys, and you can tell. I mean, he's very serious on the mound, and he's under 6 foot tall, and to be the kind of major league pitcher that he is, it's pretty impressive, and it comes with obviously a lot of dedication.
Well, do you think we could get him in here? Because we really are just a stone's throw from Truist Park as we speak.
I don't know. We could ask him. I doubt I think he's busy rehabbing right now, trying to get back on the mound. But you know what? We could ask him.
Yeah. Well, Josh, it's great to have you here today. Now, you've been a lawyer at the firm for quite some time, but I don't think have you been on a podcast episode before?
No, this is my first time.
Okay.
Glad to be here.
Awesome. Well, we've got an interesting topic today. Robert, what are we talking about? AR 15-6? Is that what it's called?
Yeah, we're talking about 15-6 investigations today.
All right, cool. Well, before we do that, we usually do a pre-show topic, and since Josh is our guest of honor today, we'll let him decide between these options. One, he can talk about his background, what he did in the Army before he joined Capovilla and Williams. I don't know that he's going to pick that topic. The other would be your favorite historical site, since we were kind of talking about that pre-show. Robert is kind of a history buff, and so we could do your favorite historical site. Now, we've got to kind of cut that conversation off after a few minutes because it could go on for a long time. Or we could talk about the conclave with the Pope, which just started not too long ago. Now, these recordings sometimes don't come out for a little while, but the conclave is in motion as we speak. So, Josh, the topic you'd like to talk about, sir?
Well, I don't want to give Rob the opportunity to keep us here until midnight, so I'll do some background, I suppose.
Nice.
Yeah, so I joined the Army in 2016 as an enlisted guy, as a paralegal. I served at Fort Gordon, now Fort Eisenhower, for the most of that time as the TDS paralegal NCO, right? And that's where I met Rob. Actually, Rob came as a civilian on a trial. We worked together on that trial. At the end of my active duty time, I went to law school. While I was in law school, I was in the reserves, where I again ran into Rob and then Mickey. I got to work with them in the reserves while I was in law school. And when I graduated, I came on to the firm as an attorney full time.
And it's been a couple years now, right?
Yeah, going on 3.
Yeah. Perfect. How would you, rate Josh's performance at Capovilla and Williams up to this date?
Here we go.
I think Josh is exceptional. I think Josh has turned himself in over the last 5 years, which is about the timeline he's been with us in one capacity or another. I think he's turned himself into one of the very best military administrative attorneys in the country. He's dedicated. He takes care of his clients. He handles our staff and our resources really well. He gets outstanding results. And the thing I like about Josh, maybe the thing I like about Josh the most is Josh really embodies, one of our primary core values of honesty. If you ever work with Josh and you're his client, Josh is going to tell you what you need to know and not always what you want to hear. And that's vital when it comes to getting the good results that we need for our clients. A lot of times folks will think that lawyers are paid to tell you what you want to know. And that's, the exact opposite of what we stand for in a lot of ways. I think one of the reasons Josh gets such outstanding results is because he's not afraid to have difficult conversations with his clients, because every case has got bad facts to some extent. And the great lawyers and the good lawyers know how to address those facts and then overcome them. The bad lawyers will just tell you that everything is great and you've got a perfect case, and then you end up losing and you wonder why.
Yeah.
So Josh is outstanding. I have nothing bad to say about Josh.
Well, Josh, and I know Rob talks to me a lot about your performance, and it's been spectacular. So thank you very much. I got one more question, and then we'll move on to our topic of the day. But what is the biggest difference between working cases in the military from within, I guess TDS, versus kind of as a civilian from your perspective?
Yeah, it's got to be resources. 100% it's resources, right? When you're TDS, you're this small shop in charge of everyone who needs defense services on the entire base, right? They don't have investigators. They don't have an adequate number of paralegals, if they have paralegals at all, right?
Yeah.
They don't have an adequate number of attorneys. They don't have an adequate amount of time to deal with all of the cases. I think that here at our firm, we have a robust team on our staff to make sure that we can cover your case from beginning to end from every angle, right? Multiple investigators ready to jump on at any time to dig into the facts and get what we need to be successful. We have paralegals, legal assistants to assist us with organization, to assist us with making sure that you're receiving all the updates you need. We have everything we need to take care of you, and it's just not the same on active duty.
Yeah. Yeah, they just don't have the resources. They can't spend the time. You have hundreds and hundreds and hundreds of files to deal with, I would imagine.
Mm-hmm.
Well, it's great to have you as part of the firm, Josh. I know Robert feels that way. So does Mickey and the rest of the team. Great to have you in the podcast studio today. We're looking forward to a great episode. And with that, I'm going to turn it over to Robert to kind of, I guess, introduce the topic, and then we'll get down to the nuts and bolts of it.
Yeah, so today we're talking about 15-6 investigations. A lot of this information that we talk about is also applicable to the other branches, right? Whether it's a command-directed investigation or an investigation by an investigating officer in the Navy. A lot of these principles are the same. And I've asked Josh in particular to come in and to talk to us about 15-6s, because I'm not sure there's an attorney in America who works 15-6s more than Josh does. I'm not sure there's a military attorney in America that's gotten better results than Josh has with his 15-6s and his responses. And so I wanted him to come on and sort of share some of his wisdom and share, his approach to these cases, and also just talk a little bit about what 15-6s are, because we get calls on these all the time. And it's important that folks understand what a 15-6 is. What is the IO's responsibility, what rights they have under the regulation. And then, of course, we'll talk a little bit about best practices and how to be successful in hopefully unsubstantiating the allegations and also responding with really powerful rebuttals to the allegations. So without further ado, Josh, why don't you tell us first, what is a 15-6 investigation?
Yeah. So when we say 15-6, what we're talking about is Army Regulation 15-6. It's talking about or covering investigations initiated by command and boards of inquiry, right? And really what this is the commander receiving allegations through one channel or another and saying, hey, I have a duty to investigate this and make sure that I'm instilling good order and discipline. So the commander is going to appoint a neutral and unbiased investigator to go out and find out certain facts, right? There's going to be an appointment memo that comes out from the commander. The investigator is going to follow that appointment memo along with legal advice from the JAG office. He's going to reach out to witnesses, gather evidence, and try to determine what happened, right? He's going to take his answer back to the commander, for the commander to decide what to do with it. That's kind of the nuts and bolts of it. When we're talking about a 15-6, from our firm's perspective, we're talking about a client who's had allegations lodged against them, and they've come to us saying, hey, I don't know what to do, right? I don't know what's coming. I don't know who's on my side and who's not on my side. My career is in danger. Help us, right? And so we're there to guide them through that complicated process, make sure that they're taking the right steps to protect their career.
Now, Josh, what is the role of the investigating officer? I was a legal advisor on dozens of 15-6s when I was active duty. We obviously worked them just about every single day at Capovilla Williams. I know we talk about investigating officers a lot, about how sometimes they're not always the most qualified, or sometimes they don't always follow the guidance and the regulation. But just talk to us for a few minutes here. What is an investigating officer supposed to do?
Yeah, so again, I mentioned that appointment memo. That's supposed to give them their left and right limits. It's supposed to say, hey, this is the allegation. This is the subject of that allegation. I need you to go out and determine, with the help of the evidence available, right, witnesses, documents if it is, videos, determine what actually happened so the commander can make the right decision. Now, that investigating officer is required under regulation to be neutral and unbiased. They can't know anything about the investigation. They can't have any inside information about the subject or the other witnesses. They have to truly come into this in a neutral fashion, right? Not having their minds made up, not just trying to give the commander the answers that they want, right?
Are they a trained professional? Is this their full-time job, this investigating officer? Are they like you would think, like a detective in a local municipality, or something different?
That's a great question. No, not at all. Right, they are just a random officer in the command under the commander's purview, and they get a brief from the legal office. It's probably like a 10-minute brief that they give to everybody. It's very minimal, and they're told, go forth and figure it out.
When you say a random officer, what does that mean? This could be somebody who drives tanks, or
Yeah.
I don't understand.
100%. Yeah, so it's whoever the commander can appoint at that given time. Right. They don't have to have experience with investigations. They are pulled from their normal job. They said, hey, you're no longer doing your normal job, whatever that job was. I mean, it could be anything. You're now going to be an investigator, and that's your primary place of duty until you've completed the investigation. The requirements, Matt, are that they outrank the accused, right? And that they are neutral and unbiased. That's it.
It's funny you asked that question, Matt, because I've said many times, I think I've even said on this podcast when we talked about Gomar's, I think it was last year, that I think, considering how important 15-6 investigations are to the careers of those being investigated, I think if I had any power or say over it, there should be an MOS of investigators that are trained, that know how to conduct these investigations, because it is wild sometimes, literally wild, what we deal with from investigators. I mean, literally, I've had investigators tell me, I remember one, he was a captain, and he said, I know your guy's guilty, and I'm going to go prove it to the commander. This is before he talked to anybody. All I did was submit a notice of representation. I then followed up and submitted a request to have him removed, and of course it was denied because I couldn't show a finding of bias, but which I thought was ridiculously funny. We ended up winning that case, by the way. But yeah, they're not highly trained folks when it comes to investigations, and they can come from anywhere. I mean, they come from the S1 office, the S2 office. They can be, they can be a logistics officer. They can be all kinds of stuff. And once they're appointed, that becomes their primary duty. They're supposed to put aside everything else for the time the investigation kicks off until they finalize their findings and recommendations. Also, they're going to be given a judge advocate. They're going to have a legal advisor who's typically a very junior judge advocate, usually out of the administrative law department. And the judge advocate's job is to make sure that the investigation is legally sound. And typically, the legal review is about a paragraph that says, "Oh, this is good to go." I'm not even sure how thorough of a review is actually conducted. I've often wondered that. I used to advise these folks, and I would do a fairly significant review because I would understand that there's a soldier whose life and career is at stake. But yeah, it's kind of the Wild West.
It's hard to surprise me with weird things in military justice these days, but it's shocking to hear that they would just pull somebody out of another job and have them investigating something. I'm sure we could do a full episode on just investigators and investigation regarding these issues, but it's shocking to me. Not to mention, if you're that guy or gal, you don't want to be doing that, right? I mean, let's say you're in the midst of an important project in your normal workload and your position, and you really want to be pulled out and asked to do something you have no comfort level doing. I mean, it's bizarre to me, but I can't say I'm overly surprised.
Yeah, and it shows their lack of experience, their lack of training when you see that report of investigation. At the end of everything, they send that over to the command, and you got to think you've got all manner of MOSs, right? All manner of jobs out here who are tasked with analyzing whether or not someone violated the law, right? So they're tasked with analyzing, hey, did they meet these elements of this allegation under the UCMJ? And they are not equipped to do that, right? And it shows in their analysis. They don't understand what they're analyzing, and it comes up with very poor results.
Yeah, that's crazy.
And, I've often thought, too, like, even if we didn't have a second MOS, there's a lot of secondary jobs in the military, right? We've got people that go to sharp courses and all kinds of different stuff. There should be something like that for 15-6 officers, because Josh is spot on in his analysis, which is those folks are not equipped to handle probably 90% of the allegations because they don't understand how to apply facts to elements of an offense. Especially if it's a relatively complex case with conflicting evidence, right? And conflicting statements. They really don't know how to handle that stuff. And the person who pays the price for that is the person being accused, because it appears to me the default is, well, if there's any question about what happened here, that means he or she probably did it, which is the exact opposite of really how it's supposed to work. But Josh, let's talk a little bit about what kind of allegations are typically investigated by a 15-6 officer.
Yeah, so I'll answer that by starting off with what's not investigated by them, right? There are certain allegations that jurisdiction is withheld up to CID, right? So more serious, obviously, murder, sex assault, those kinds of things are going to be taken out of their hands, right? So usually when you have a 15-6 investigation, it's going to be something like sexual harassment, right? It's going to be something like a barracks fight, right? Were you drunk on duty? Is there an instance of adultery here, right? So it's these quote lesser allegations. In I would say the most predominant things that we deal with on a day-to-day are going to be your sexual harassment, adultery. Those are the most prominent ones that we see.
Yeah, no, I agree with that. The toxic command climate stuff falls under this too, right? If there's been an attack on like the leadership style of a particular leader, that falls under 15-6 as well. Mm-hmm. And I always get very nervous for our clients who are accused of sexual harassment and it's being investigated under 15-6, because the Army's not done a particularly good job of clearly defining what sexual harassment is. You have the definition under the reg, and then you also have the definition under Article 134 of the Uniform Code of Military Justice. And it has a subjective element. It has an objective element. And those things are not particularly easy to understand or apply. And I find that when it comes to sexual harassment in general, the IOs just default to, if the person making the accusation felt uncomfortable, then it must be sexual harassment. And that's a far cry from what the law actually says. And of course, if there's a founded allegation of sexual harassment through the 15-6 process under President Biden's policy, that could lead to, and almost certainly will lead to, an initiation of separation. So we're talking about big deal stuff. Josh, do you agree, or am I just off in left field?
No, 100%. And it's actually shocking to me how often I see this exact thing in the findings memo. I see the IO just copy paste the definition of sexual harassment and then say, and these elements are met, right? They don't break down whether there's a subjective, a finding under the subjective element or the objective element, right? They simply copy paste, say, yep, she said it was hostile, so it's done. And then you're exactly right, Rob. That's going to initiate a separation.
Yeah, no, it's kind of a wild world when it comes to an investigating officer dealing with the more complex aspects of sexual harassment, which again, I don't want to call the definitions conflicting, but they also don't match up with each other exactly either.
Mm-hmm.
And my heart really hurts for the soldiers out there who there's a substantiated sexual harassment allegation against them, even though there's conflicting evidence, even though there's witnesses that say they didn't hear or see anything like the accuser is alleging, and yet simply because somebody says they were offended or uncomfortable, the IO just determines that it was, in fact, sexual harassment. I think about that a lot, actually, Josh, and it's a shame that that's where we are. And it's one of the reasons why I think there ought to be additional training for a 15-6 investigating officer. Okay, Josh. So let's say we've got an NCO, senior NCO. He's been accused of adultery or sexual harassment. He's been notified that there's an IO been appointed, and an investigation is kicked off. What rights does that NCO have in the 15-6 process?
Yeah, it's a great question. And it's something that's not always clear to these soldiers, right? First and foremost, they have a right to know what they're accused of, right? So if this IO calls them up and says, hey, I want you to make a statement, I want you to meet with me, and I want to interview you, and they say, oh, hey, what is this about? And the IO says, come talk to me and I'll tell you. That is inappropriate, right? That is incorrect. That is not how the process is supposed to go. So they have a right to know what they're accused of. They have a right to seek counsel, right? Their 31 Bravo rights say that the investigating officer has to notify them of their right to remain silent, the right to counsel, the right to not make a statement at all, right? So they can pause that interview and they can go seek advice from a defense attorney. They have the right to participate in that investigation. They have the right to make a statement, submit evidence, submit witnesses. And then there are other rights, depending on your rank and depending on the subject matter, that may kick in later in the process. But those are the basics at the very beginning. You have the right to know what you're accused of. You have the right to participate, and you have the right to seek counsel.
And I got to say, one of the things that I've noticed, in particular with senior NCOs or, and quite frankly, your junior level officers, right, is they want to handle this on their own, right? Okay, well, there's an IO that's been appointed. I'm accused of this. I'm accused of that, but I'm going to go in there and tell them what I think without a lawyer. And I tell these guys all the time, look, man, you got to do what you got to do. I get your type A personality. I get that it has probably helped you up to this point in your career, but you're venturing into a world you don't know anything about. If you say one thing in that interview that is contradicted by the evidence, not only are you going to be under investigation for the underlying alleged misconduct, they're then going to come after you for a false official statement. And I usually tell folks, I usually say something like this. Listen, if I tried to go do your job, right? If I tried to go be an infantry officer for a week or a month, I would make some serious mistakes because I don't know that stuff. And yet a lot of time these soldiers think they can handle the investigation when in reality, there's a lot more going on than they think about, and everything they say and do can be used against you. So for anybody listening to this that is facing a 15-6 investigation, here's some free advice. And Matt, don't forget the disclaimer at the end that says we can't give legal advice, but here's some free advice nonetheless. Don't try to handle it on your own. If you can afford a lawyer, hire one. God knows they're there to help you. And if you can't, try to get assistance from whoever is in the TDS office or the legal assistance office. I know those folks aren't that experienced, but they're better than nothing, because if you go in there and mess this up, you only got one shot and it could end up real bad for you.
Yeah. And Rob, how many times have you heard this one, right? I'm innocent. I didn't do anything wrong. So why wouldn't I make a statement, right? And everything that you just said is the answer to that question, because you don't know what you don't know. You don't know if they're ready to twist your words. You don't know if there are statements that are going to be contradictory to what you have to say. You don't know if you're going to get slapped with an Article 107 because they think that you lied, right?
Article 107 being
a false official statement. Good question, Matt.
Okay. So, Rob, one of the things that I found interesting, so many people seem to call your office and not really know what they're being accused of. Josh had said that they're supposed to know. They have a right to know. Am I confusing two things, or do a lot of these guys who call you, they don't really know, right? They said, I've been called in, or they want to talk to me, not really sure what's going on. They don't really know, though, do they?
No, they typically don't know, and that's typically an investigation tactic, right? Don't tell them what what they're accused of until they're there, hope they're not prepared to make a statement, and catch them in either an inconsistency, a lie, or get them to incriminate themselves. That's the danger. And, what I tell the guys that call our office all the time is if you have a goal in mind, which if you're under investigation, your goal should be straightforward, right? I want to get these allegations dropped, or if I made a mistake and I know I made a mistake, I want to minimize it as much as possible. You better be intentional about that. No matter what you want to accomplish in life, if it's better physical fitness, if it's starting a business, right? You need to get intentional about what you want to accomplish. And so many of our service members are intentional about the right things, their career, their fitness, all those kinds of things. And yet when they come under investigation, they'll go talk to a mentor or something who will be like, well, just sit and wait and hope for the best. Let me tell you, and I don't mean to be disrespectful to anybody here, that's how losers think. That's how people who end up on the short end of the stick think. Get intentional about what you want with your legal matter, and your chances of success are going to go up an incredible amount. There we go.
Yeah, I mean, that's such a good point, Rob. Let me ask one more question here, and I know we've got other important things to cover, but to you, Josh, on this issue, I suspect you hear, or maybe you hear often, if I get a lawyer, it's going to make it seem like I'm guilty or I did something.
That's a great question.
And I think this goes to Rob's point of, I can fix this myself. I'm a smart guy. I haven't done anything wrong. I'm innocent.
Yeah.
So that my first question would be, how would you respond to somebody who says that? And then my second question is, how many times do you see that somebody go in and make a statement about one issue and they get charged with another issue, or it opens the door to another issue? Dan was in here not too long ago, and he talked about how, a text thread cost 6 or 7 guys their careers in the military, and the text thread wasn't even part of the initial investigation.
Yeah.
So can you take a stab at those two questions?
Yeah. So I do hear it a lot. Hey, if I hire someone, is this going to make me look bad? And absolutely not. It makes you look smart. It makes you look prepared. It makes you look like you care about your career and you're taking this seriously, right? If you go in and you bumble the investigation interview, right, and you say some stupid things or you incriminate yourself somehow, that's going to make you look bad, right? Having a professional sitting by you, communicating with the JAG office, communicating with the command, communicating with the investigating officer about things that they know intimately well, things that we do every single day, that's going to make you look like a professional, right? Yep. So it's not going to hurt you, right? I would say that you are putting yourself in the position to be successful if you bring an attorney on. And the government's going to know that.
And
right?
The other issue of how often does somebody make a statement and it leads to something else?
Yeah, more often than you would think, right? And we'll talk about kind of the steps that we take when we're helping someone through one of these investigations. But you don't know what you're walking into in that interview, and they may ask you some questions out of left field. They're going to talk to you last as the subject. They're going to talk to all these other witnesses, and so whatever the investigation kicked off for, they're going to have other questions, and they're going to try to trap you in those other questions. So you may be accused of one thing and walk out with 5 charges. Yeah. Absolutely.
Josh, you talked a little bit about some of the nuances and rights available to people who are the subject of an investigation. Dive into those rights. How are they different for officers and enlisted, and how are they different in the subject matter?
Yeah, that's a great question, Rob. So the big one is the difference between officers and enlisted. So an officer, because if they have an adverse finding, it can go to their promotion board. They automatically have a right to respond to any adverse findings before any action is taken, before the investigation can even be closed out. It's going to be referred to them. They see all of the evidence. They see the interviews with the witnesses. They see the investigating officer's report to the commander, and they get to submit a response, a written response to that. If you are enlisted, you don't get that right. That investigation goes back to the command without your input. You may not know what you're being investigated for. You may not make a statement, and then suddenly you're facing an Article 15 or a separation, and you still don't know what's happening, right? Officers have a leg up there. They get to see everything before it goes to that punishment phase, right? Now that changes if certain subject matter is involved in the 15-6, such as an EO allegation, right? A discrimination allegation or a sexual harassment allegation. Those come with the right to respond no matter who you are, right? Those come from various other regulations that have been put in place over time, and they've gotten fairly robust for a sexual harassment investigation. You have 30 duty days to respond to that, regardless if you're an E1 or a colonel, right? So those rights depend on the situation you're in, and sometimes you can be severely disadvantaged just because of who you are, what your rank is.
I find it so upsetting to me that we have the different rules in this particular context for officers and enlisted. I will never understand it. I don't think it's fair. I don't understand how, a first sergeant with 17 and a half years in doesn't have the same rights as a brand new butter bar lieutenant.
Mm-hmm.
I'm never going to understand it. I think it's disrespectful to our enlisted men that really serve as the backbone of our United States military. I mean, I watched the show Band of Brothers while I was at Fort Campbell handling a trial, and you see how important these enlisted leaders are. I mean, for any of us, Josh, that served, they really are the day-to-day leaders, and to not be given the same rights as some officers, I've always had a problem with that. But
so a non-officer, somebody who's not an officer, does not get an opportunity to respond, I would assume.
Yeah, if it's not one of those particular investigation sexual harassment EO that comes with a right because of some other regulation, they do not get to respond to that. Now, the regulation says commanders can afford them that right. And I always request that right.
We always request the right to respond.
Yeah, but the command says, you don't have a right to it. Why would I let you?
So
right?
Then it can proceed forward without them getting to tell their side of the story or see the evidence? Is that right?
That case can be on the general's desk for a GOMAR before they even really know what's happening.
Wow.
Now, that soldier's going to have the right to respond to adverse actions, right? They're going to have the right to respond to the GOMAR. They're going to have a right to fight the 15 or the Article 15. Certainly, if it goes to a court martial, obviously they're going to have all the rights of any American citizen. But yeah, I mean,
they're behind where they could have been.
They're behind. Correct. And that's why we oftentimes fight hard to get the opportunity to respond. But Josh, let's talk a little bit. You've had incredible success with 15-6s. Our firm has had some incredible results with 15-6s. What is your philosophy? How do you take us from, okay, you find out there are adverse findings. Take us through your philosophy. How do you get those results for your clients?
Yeah, I think the first thing that we want to do is get as much information as possible, right? Whether that is asking the investigating officer for their questions in writing, right? Instead of an ambush meeting, I want to see what their questions are, and that's going to clue us in to what the issues are in the investigation. The next thing I'm going to do after I have as much information as possible from that avenue, I'm going to appoint an investigating officer from our office to go out and talk to witnesses, right? Just because the investigator gets to hide what they're finding doesn't mean that we don't get to investigate. So we put together a witness list. We put together an investigative plan. We go out and we interview all of these folks, get any evidence that we need, so we are prepared to either submit that directly to the IO to be included, or we're prepared on the back end to have that conversation with the command. We may go straight to the JAG office and say, "Hey, look, this is messed up. Look at this stuff that we've uncovered. It's clearly this is an improper basis." Right. So information is the number one thing that you want to gather and have kind of in your arsenal. The next thing that you want to do is know your client's rights. Right. You want to know if they have the right to an appeal of those findings. Right. I had a case about a year ago. They hired us after the investigation was completed, and the command had their separation papers drafted and ready to go. They hired us day one. I called the JAG office and said, "Hey, where's their appeal?" The JAG office wasn't even tracking that they were entitled to an appeal because they were enlisted, right? So I cited the regulation. They got their appeal. They got a second appeal. We got a favorable outcome in the end, and they are still in the Army today because we were able to step in and use our skill, our knowledge, our information, our understanding of the regulation to slow that process down so that we could tell the command what they needed to hear to make the right decision.
That result never happens if you're trying to do it on your own, right?
That separation was on the commander's desk. They were going to be out in a week.
I cannot tell you, Matt, how many times there have been adverse findings against our clients. We get the investigation. We recognize that it's biased and incomplete, and we put one of our own investigators on. And mind you, Matt, we've got 4 investigators that used to work for Army CID and Air Force OSI that are at the top of their game. I think they have a combined more than 60 years of federal law enforcement investigation within the military. we will employ them. They will go out and they will tell the other side of the story. And that has led to some incredible results for our client out.
Follow up on your philosophy. I mean, you had started to talk about it, but your philosophy and approach, and you had talked about our own investigation. What else? What else do you do personally, or does our team do, or just should any team do this representing folks in this situation?
Yeah, you gotta help your client understand the situation that they're in, because they will want to go. They will want to say too much or give too much, or they don't understand the implications of the evidence they want to submit. They don't understand when to shut up. I mean, to be blunt about it, you have to rein them in, help them know what they're facing, help them know the right way to approach it, and you have to guide them through every single step of the process. Now, these are, I mean, experienced military members, combat veterans, but they've never done this before. This is something that we have experience in, and they don't. So you have to tell them, hey, this is not your arena. This is my arena. You need to take my advice, and you need to hold their hand through it, right? Hold their hand, explain to them what you're doing, explain to them what their rights are, explain to them what the next steps are, and make sure that they feel comfortable every step of the way.
It's got to be incredibly stressful for those folks that are in that situation. Can you talk a little bit about that? I mean, I would assume they come to you and their careers are in jeopardy, their benefits are in, their reputation, maybe their relationships with, their unit and their family members, maybe, and friends. I mean, it's got to be a very difficult thing to go through.
Yeah, oftentimes they tell me they feel ostracized. The command has removed them from the building. Removed their ability to do their job. They're sitting in S4 somewhere, right? They're sitting in S1 pushing papers. They've spent, a lot of these guys, most of their life fighting for their country, and now they're in a completely new arena, right? It's terrifying. It's frightening. They see their jobs potentially going away. They see their retirement being taken from them. Yeah, I mean, it's a very stressful situation.
I say this a lot, and I mean it, and it's important. It's as important to me today as it was when we first started Capovilla Williams all those years ago, that it's an incredibly difficult thing when the organization that you serve and that you fought for and bled for and sweated for and spent years potentially away from your loved ones all of a sudden turns its back on you. Being a soldier, being a Marine, being a sailor, being an airman, it's not a regular job, Matt. It's an identity to these people. Mm-hmm. The uniform becomes a large part of who they are. It's their standard. It's their life. It's what they think about. And so when all of a sudden that firm base that you've relied upon to get, to feed your family, to make friends, to build your life on, all of a sudden turns its back on you, these guys feel like their hearts are being broken. Mm-hmm. They feel betrayed. They feel sometimes hopeless. And I tell our team on a weekly basis that our job is not just to be lawyers. Our job is to restore hope and then to give these guys a powerful voice. And that's exactly what we do every day. And honestly, I'm as proud of that today with, 24 members of this team as I was when it was Mickey and I sitting around Mickey's kitchen table.
With the gnats.
With the
in the small office.
Yeah.
Not at his house, but at the small office with the gnats.
What Matt's referring to is the very first office we ever had a bug problem. And it's fun now to think about where we started.
Wasn't fun then, though.
Well, I don't think Mick and I knew any better back then. I think we were just trying to survive. But yes, I do remember those days rather well.
Some things you don't forget.
No, you don't.
What other topics? This has been a great episode. It'll be particularly helpful to folks going through this. Some of our topics are designed for practitioners. Some are designed for family members. I think this will be a great episode. But what else do we need to cover on this topic while we've got a few minutes left? Anything?
I think we've done a pretty good job of the overview. Obviously, there's more to it than what we've talked about. But Josh, I mean, what are your kind of parting thoughts? What are your final thoughts about all of this?
Yeah, well, I think Matt asked a really good question earlier about if I get an attorney, is it going to look bad for my case, right? I think that if you are notified of a 15-6 investigation, I think the first thing you should do is call an attorney. right? Whether you go down to the TDS office or you start making calls, you've got to get someone to represent you, and you've got to get someone that knows what they're doing, someone that has the resources and the knowledge, and who has done this time and time and time again.
But let me, if I cut you off, Josh, and I hate to do that because I know you've got more points to make, but just because somebody calls an attorney doesn't mean they have to hire an attorney.
Yeah.
I mean, you guys will talk to them at no charge,
Yes,
and at least give them some options, right? So, I mean, there's literally no risk to talking to somebody at Capovilla and Williams or some other law office for that matter.
Yes.
You're not obligated to hire anybody.
Yep.
Just have that conversation.
Yeah, you're going to work closely with this person, right? And you need to trust them because it's your career on the line, right? And maybe more than your career on the line. So make sure that you vet those people. You talk to them, have a conversation, gauge their knowledge, look at their website, see what kind of resources they do have. Make sure that's someone that you can place your career in their hands comfortably.
And here's what else I would say. That there's no, if you are an individual under investigation, whether it's a 15-6 or a CDI in the Air Force or a command investigation in the Navy, there's no case too big or too small for us to assist with. Mm-hmm. We've helped everybody from the E3, E4 to the general officer who is facing command investigation. We were lead counsel on the Vanessa Guillen sexual harassment 15-6 that ended up being 2,000 pages long. And while the media never covered what actually happened in that particular case, our client was never court-martialed. He was never separated. All of his benefits are intact today. So there's nothing that could happen in a 15-6 or command investigation, Matt, that we have not seen. We will know how to deal with it. We will know how to approach it. And we're all everybody at Capovilla Williams is a professional. We're also not going to go in there and blow up your case. We're not going to cuss out an IO. We're not going to cause you problems with your command. We're going to handle things tactfully, intelligently, as, professionals should. And then you're damn right. If our clients' rights are being violated, we're certainly going to make sure to put an end to that because that's what these guys, our men and women in uniform, deserve. They deserve strong voices, smart voices, tactical voices, and quite frankly, their rights need to be protected. And sometimes their own leaders forget that.
Mm-hmm.
Well, very good point. Excellent points by both of you. One thing I don't know that we covered that much. If we did, I missed it. And we can always edit things out. But what are the repercussions of these? Like what happens after? We talked about the investigation. Can we talk just a little bit about the potential things that can happen?
Yeah, so for an officer, we mentioned this earlier, the investigation, the findings itself can go into your promotion file, right? So if you have adverse findings, right off the bat, you have something that's going to end your career, potentially. It's going to be very hard to be promoted. And if you do not promote, you're going to be kicked out, right? Beyond that, once an adverse finding is confirmed by the commander, they can take any administrative action against you that they wish to take. Whether that's in Article 15, they can take your rank depending on where you're at in your career. They can take your pay. They can put you on extra duty. They can put that Article 15 again in your permanent file. That's going to end your career. They can give you a general officer memorandum of reprimand. Right, that's something that's going to go in your file and end your career. They can separate you. They can go straight to a separation hearing. And if you do not have 6 years in, they can separate you on paper. Just a small packet of paper. You get a small chance to rebut that, and then you're out of the military.
Wow.
So these can have vast career-ending repercussions.
Could it advance to something else? Could it advance to like a court-martial or something else?
Absolutely.
On what the findings are?
Yeah, absolutely. If the investigating officer, and I see this happen quite a bit, the investigating officer hears one of the witnesses say something that takes this investigation out of their jurisdiction, and the first thing they're going to do is call CID. CID is going to open a case, and now you have 2 investigations. One is a formal federal law enforcement investigation against you, and that can lead anywhere up to a court-martial.
And quite frankly, 15-6s sometimes lead to court-martials.
Sure.
We've got 2 cases at Capovilla Capovilla Williams right now with drill instructors, right?
Mm-hmm.
Drill sergeants that started with 15-6s for maltreatment, and both of those are being court-martialed. And so it is serious. You've got to take it seriously. You've got to be prepared to defend yourself. And don't try to handle it on your own. I thought Josh did a really good job today breaking it all down.
Great job.
And for those that don't know, because this is not being video recorded, Josh also has the best mustache in the business.
Wyatt Earp.
And I think that's part of the reason he gets some of the success he gets.
Yep.
I
Well,
appreciate
and you're
that.
going to drill here pretty soon, aren't you? Or some kind of training or something?
Yeah, I'll be on annual training, so I'm going to have to trim it up.
So how are you going to do? How are you going to do?
Oh, fantastic, man.
Yeah?
Fantastic.
Robert, how would you do in annual training right now if you had to?
Oh, who knows? I don't even want to think about it. I gave up annual training a very, very long time ago.
The last annual training I did with Rob, I graded his ACFT. He did pretty good. He did pretty
What
good.
is that?
His physical fitness test. Now,
Oh.
I will say Mickey flew by him on the run, though.
Yeah, but I did better. Believe it or not, I outdid him pretty considerably on the deadlift.
Did you?
I did.
Nice.
And you can
I did.
outshoot him if
And
needed,
no,
right?
no.
What do you mean?
No. There's some
You
things.
can't outshoot him?
No. There's some things I do better than Mickey from a physical fitness standpoint. I'm actually strong. I think from a pound-to-pound aspect, I lift more weight than he does, or at least I did then. But
If he was here now with his biceps popping out of his polo, you wouldn't be talking like
I'm
this.
just telling you, he would admit it. Ask him next time he's on here. Now, Mickey's far more jacked than I am, and he's far more serious about his diet. But when it comes to shooting, I certainly could not outshoot Mickey, and I couldn't even come particularly close.
He takes it very seriously.
That's funny.
Yes. Yeah.
Well, guys, great episode today. I always like the episodes that speak to prospective clients or clients. I think it's great information that we've given. I am going to put the disclaimer out there that none of what we talk about here is or should be construed as legal advice. Certainly doesn't create an attorney-client privilege. A lot of this information is well known within the industry among lawyers that do this kind of work. But if you need help, get help. By all means, call our firm, call some other firm. But thanks again for tuning in, everybody. We'll see you next time on the Military Justice Today podcast. Until then, take care and be safe.
Thanks for listening to the Military Justice Today podcast with your hosts, Robert Capovilla and Mickey Williams. This show was made possible in part by the law firm of Capovilla and Williams. For more information or to listen to more episodes, visit militaryjusticetoday.com.